We're going straight to begin our conversation for today. What happened in court? What is the ramification? What is the impact of what happened in court today? Okay, let's get onto our screen. With this matter, the guys, the Fix the Country people, went to court seeking two reliefs that we have paraphrased as follows. Relief number one, they were seeking an order from the Supreme Court to quash the perpetual injunction granted by the High Court, not the Ninth Court, sorry about that, granted by the High Court in favor of, not if, in favor of the police against the demonstration. So they were seeking an order of the Supreme Court to quash the perpetual injunction granted by the High Court. Okay. Number two, they were seeking a restraining order. They were seeking a restraining order to be effected against the Ghana Police Service, preventing them from interfering with their human rights. This is how we captured it in our own language. So two reliefs they were seeking in court today. When you listen to the news, they don't really talk about that. But it's two reliefs they were seeking. First, they were looking for an order of the Supreme Court to quash the perpetual aspect of the injunction. So the injunction was granted, that it was granted in perpetuity. And they went to court and said, you can't grant an injunction against our constitutional rights perpetually, which is correct. We believe that is correct in law. And so they went to tell the Supreme Court that you can't, the High Court should not have done that. That's relief number one. Relief number two, they were asking the Supreme Court to restrain the Ghana Police Service from interfering with them, the Fix the Country conveners, about their demonstration and their movements and etc., etc. So two reliefs went to court. Now let's move on and see how they defended their reliefs. Now the photograph of the nice gentleman we put here is Justice Sremsai. Justice is his name. He's not a judge of the Supreme Court, but he's a very favorite lecturer of many young people at GIMPA, where he teaches constitutional law. And he writes quite a bit on Facebook. You can follow him if you like. His name is Sremsai. Now, he said as follows, that the campaigners, this were his words, insist that this order is unlawful, as under the High Court's rules, injunctions granted without argument by the affected persons, which is ex parte, ought to last for just 10 days. So they went to court and made the point that the time-tested rule, and we'll show you that rule, in the civil procedure, High Court civil procedure rules, is such that an injunction, when it's granted, is granted for 10 days. An injunction granted ex parte all the time automatically would lapse after 10 days. What then happens is that the applicants for the injunction, even if they succeed, they will have to reapply within the 10-day period back to the court, this time not as ex parte, but on notice to the other party. And the police have done that, but we'll get into the story. So this is the argument that he presented before the court. The learned Attorney General, Godfrey Adom-Otchere, who was in court, also presented his arguments against the arguments of the people. What did he say? He said as follows. He described the case filed by the campaigners as misconceived and completely unwarranted. He explained that under the High Court's rules, ex parte orders are to last for 10 days. He added that by the operation of the law, the order granted on May 6th, stopping the May 9th protest, has since elapsed. He therefore urged the court to dismiss the case since no order is in force currently barring the protest. So that was Godfrey Adom-Otchere's argument. Let's just go through it so we understand. So he's saying that the campaigners are in court on a mischief and on a misconceived understanding of the process of the law. He also says that their application before the court is unwarranted because he's explaining that under the High Court civil procedure rules, the order that was given on May 6th is given to lapse for 10 days only. And therefore, within that 10 days, it has lapsed. So there's really no order right now. What there is the application the police have filed on notice, which the conveners have notice of, about which they have been in court last Friday, and about which they'll be in court on the 14th of June. So that, as far as the Supreme Court is concerned, the Attorney General was urging on the court that currently there's actually no order in force. So if there's no order in force, then you cannot grant, you cannot set aside an injunction. You can't do anything about an order that doesn't exist, because as far as he was concerned, the order didn't exist. Okay, let's look at what the Supreme Court said. Okay, before that, this is the rule. We reproduced this rule so that we can make the point about, you've heard me say 10 days, 10 days. Where does it say 10 days? Where is the fact of the law? It is here. It's Order 25. High Court civil procedures have rules. So what happens is that there's a rules committee at the court presided over by the Lord Chief Justice. That designs the rules of the court. When they design it, they send it to Parliament for Parliament to approve because it becomes a sub-law. Those are called the rules of courts. That is how courts work. That's the procedure. When people finish the law degree at a university and they go to a law school in Makola, that's what they go to learn. They go to learn the procedures. So people don't learn criminal law at Makola Law School. They don't learn civil law over there. They don't learn, they learn tort law and they go and learn civil procedure. They learn criminal law, they go and learn criminal procedure. So what happens there is the procedure. It's a whole big bunch set of rules. So this is, and that's how they are called. They are called orders, order something, rule something. So in order 25, I'm looking for rule 9, Kweku. Is that what you've given me? Order 25, interlocutory injunction, interim preservation of order. Okay. So rule 1 is the court may grant an injunction. So this is 25. We'll get to 9. It says the court may grant an injunction by an interlocutory order in all cases in which it appears. Sorry, I don't need this. I just need order 25, rule 9. This is not, this is okay. So do we have 9? Okay, this is all I need for the viewers. So order 25, rule 9, it says, where an order is made pursuant to an application made ex parte under sub-rule 3, it shall not remain in force for more than 10 days. That's the rule. That's order 25, rule 19. Order 25, High Court Civil Procedure. So this is what everyone is relying on. This is what the order says. It says, where an order is made pursuant to an application made ex parte under the sub-rule 3, it shall not remain in force for more than 10 days. Okay, so let's come to the ruling of the court today. The court in this ruling noted that the rules of the High Court allow such ex parte injunctions to last for only 10 days. We showed you that. It thus said the judge erred. The court therefore proceeded to quash that portion of the order that barred the group indefinitely. I don't know whether you get that. So what the court did today is that the High Court is not supposed to give the rule beyond 10 days. If the High Court judge gave the rule beyond 10 days, then the Supreme Court is quashing the extra days, 11 day, 12 day, 13 day, 14 day, whatever the judge did, which he did in perpetuity or he did it perpetually. All that is quashed. That's all what happened in courts today. So that's what happened. That's what the Supreme Court decided. Let's look at the Supreme Court judges. They'll put it on now. The Supreme Court judges who dealt with the matter. So the presiding judge was this man, Mr. Yawa, and you know that Yawa is one of the senior judges of the Supreme Court, one of the 3 seniors. He presided over the matter, and he read the ruling of the court and said that the court is excluding the other days on which the injunction was given. That injunction has lapsed. It's of no consequence right now. The police are back in court. They are back in court with the Fix the Country people. That's the point the Attorney General was making, that this is a no case at all. But anyway, the Supreme Court proceeded to give a ruling on it, and the Fix the Country people have claimed victory, and they have believed that the Attorney General has lost the case. So Yawa was a presiding judge in the matter. There was another relief that the Fix the Country people were seeking, the second relief. They were seeking a restraining order on the police. The court refused that. The court refused to grant them that. So that is clear, and that the Fix the Country cannot proceed on a demonstration tomorrow. They cannot proceed on a demonstration the day after. They have to participate in the court processes that come up again on the 14th of June. We don't know yet whether the ruling will be on that day, but on the 14th of June is the next hearing date. So what has happened in court really is not much. It's not much. But Justice Yawa was the presiding judge, and he was assisted by Justice Mariam Owusu, also one of the senior-most judges at the court. Is that Mariam Owusu? Okay. And then this is Justice Avril Lovelace Johnson, who was also part of the panel today at the Supreme Court. And then there were quite a few women on it. Justice Clemence Honenuga was also there, one of the senior people. Then Professor Henrietta Mensah Bonsu was also there. So this was the 5: Henrietta Mensah Bonsu, Clement Onenuga, Justice Avril Lovelace Johnson, Mariam Owusu, and Justice Yawa Apau. These were the men who delivered the judgment. So now you understand what it is. So what are the ramifications of the matter? In 2 minutes, I'll deal with that, and then we are done. The first thing is that a High Court judge should not, when he's granting an ex parte application by the police to prevent a demonstration, should not do that in perpetuity. High Court Civil Procedure Rules, Order 25, Rule 9 is clear on the matter. Whatever injunction that is given ex parte must be given for 10 days only. The applicants knew that, the Attorney General knew that, the Supreme Court knew that. The 10 days had elapsed, everybody knew that, so there was no point. The police have filed another case on notice wherein Let's Fix the Country people have been served. And they had been in court last Friday. They're going to court again. So everybody knows that. But they had filed a Supreme Court case earlier. The Attorney General urged the court to dismiss the application. The court decided to take the occasion to make a substantial ruling that judges cannot extend an ex parte grant of an injunction beyond 10 days. Okay, so that was done. Second thing, they were asking the court for a restraining order for the police not to interfere with their constitutional right. The court said, no, we can't do that. Whenever you want to demonstrate, you still have to engage with the police. So Fix the Country will demonstrate. They have to demonstrate. They can demonstrate. I may not join the demonstration. I may join, you may not join. But before they demonstrate, they will have to have the consent, maybe the concurrence of the police, and then they can go together. Right now, they are in court with the police, and whatever happens on the 14th will make a determination whether the COVID violations should permit a demonstration or not. But they have been strengthened in this COVID situation by what happened at Sir John's funeral. You know that they have also filed an application to the police asking for prosecution, with the exception of the presidents who cannot be prosecuted. All the important people who were at Sir John's funeral, they're asking for some prosecution. This makes Ghana's democracy very interesting and very powerful, so that's okay. But for what happened in courts now, it's just a Pyrrhic victory. Nothing really happened because they are in court with the police. The other point that I want to make, which is very important to me, is that where are those who have been talking about culture of silence? And where are those who have been talking about a one-sided Supreme Court that is not independent? This is very important for you. Those of you talking about a one-sided Supreme Court that's not independent, have a look at this and tell us whether the Supreme Court is independent or not. No, don't go to hide. No, don't pretend that you haven't seen it. Because whenever the Supreme Court has given a ruling, and we currently know that there's a matter before the General Legal Council about the conversations about the independence or otherwise of the Supreme Court. Those of you who have said that the Attorney General goes to court and always wins. Those who have said there's a culture of silence in Ghana. Fix the Country has won a Supreme Court case. Those who said there's a culture of silence in Ghana and that it is also being manifested by important democratic institutions like the police and the court, Fix the Country have gone to that same Supreme Court and won a judgment against the Attorney General. That's the beauty of democracy. We should all be matured and understand that when you go to court and you have lost a matter, don't quickly jump to criticize the independence of the judiciary. It's not fair to do that. It's not even good to do that. It's not mature to do that. It's unintellectual to do that. Because today, the Supreme Court, the same Supreme Court, have delivered a judgment against the Attorney General. They have delivered a judgment against the government. They have delivered the judgment in favor of Fix the Country. Fix the Country, an opposition online movement of young people who are angry with what is happening in government. They are angry with hardships. They wanted to do a demonstration. The police said, no, you can't do a demonstration. The Supreme Court is telling the High Court that you can't stop them forever from doing a demonstration. That's a victory for democracy. It is a victory for Fix the Country, but it's a victory for democracy. It indicates that those who said our Supreme Court is not independent, they should come again. And from tomorrow, I'll be looking at Twitter, I'll be looking at Facebook, and see whether there are people who have the boldness to come up and say something about this matter. Because the Supreme Court has ruled the other way. The Supreme Court have been criticized for not being independent in election petition. They've been generally criticized. Today, they have delivered a ruling the other way. Is anybody looking at it to come and talk about there's no culture of silence in Ghana, to come and talk about the balance? Let's wait for them, because this is how we build a nation. I'll end with the police statement that was released just minutes after the ruling. So this is the police statement that was released. They'll put it on the screen so you can read it with me. It says the Supreme Court's ruling in the matter of the Republic versus High Court Criminal Division 1 ex parte conveners of the Fix the Country protest. The above case was heard by the Supreme Court on Tuesday, 8 June 2021, with His Lordship Justice Yao presiding. 2. The Supreme Court quashed an earlier order granted ex parte by the High Court on May 2021, restraining the conveners of the Fix the Country protest from embarking on a public demonstration. The decision by the Supreme Court was based on the indefinite terms in which the ex parte order was made. However, the Supreme Court refused to restrain the Ghana Police Service. That's 3. Very important. The Supreme Court refused to restrain the Ghana Police Service or their agents, assigns, workmen, or workwomen from unlawfully interfering with the constitutional right of the conveners of the Fix the Country protest from embarking on a public demonstration. 4. The substantive case between the police and the conveners of their right to demonstrate is still pending at the High Court Criminal Division 1 Accra and slated for hearing on Monday, 14th of June 2021. 5. The public is advised to disregard any call to demonstrate by the conveners of the Fix the Country protest march without complying with the provisions of the Public Order Act 1994, Act 491. And this is by Efia Tenge, Deputy Superintendent of Police, DSP, Head Public Affairs Unit in Accra. So that's the statement issued by the police. Our important intervention is that here is an example of, what do you call it? It's an example of a Supreme Court that's independent. Is that, are we going to say that? The independent Supreme Court. So we're going to change the narrative from the Supreme Court is not independent to, oh, the Supreme Court can be independent sometimes. And then we're going to change the narrative from culture of silence that actually the Supreme Court can speak. Yeah.